Hello, everyone, and welcome to Dorsey and Whitney's Supreme Court term, highlights of 20, preview of 21. I'd like to introduce Steve Wells, a partner in Dorsey's commercial litigation group. Steve?
Okay, thanks, Rima, and thanks everyone for joining us today. I'm Steve Wells, and with me is Tim Droske. We're the co-chairs of Dorsey's Appellate group, and I'd also like to thank Nick Tygeson, our colleague at Dorsey, who helped put together some of the materials that are available to you and helped us with this presentation. We're going to do some of the things that we've done in the past and some new things today. So we'll be talking about the last term and some of the more interesting cases from the last term. But the reality is some of the developments during the last term that really aren't necessarily based on any of the cases, and some trends in the cases that are coming up this term are really, really interesting. And we'll be talking a little bit about what's on the docket coming up, and we'll be talking about two aspects of the recent Supreme Court jurisprudence, one being Justice Barrett's impact at the court, and the other, we're going to do a bit of a deep dive into the shadow docket, which has taken on enormous importance in the last few years, and we'll talk a little bit about why that is. Our program today, because we're going to do things a little bit differently, is 75 minutes. We hope that we have some time to answer any of your questions. Please put them in the chat function if you have any. And so with that, off we go. Let me just say though, before I turn it over to Tim to talk about some statistics, we already know that this term is going to be different than the past. We have some of the justices who are making public statements, trying to dissuade the public that they are, in the words of Justice Barrett, political hacks. I think the court is rightly concerned that the public, at least according to opinion polls, think otherwise. And we have Justice Thomas, who yesterday kicked off both oral arguments with the first question for both arguments. And those of us who have followed Justice Thomas recognize how rare that circumstance was. So it's likely that this upcoming term is going to be like no other. Tim, take us through some of the statistics from last term.
Yeah, well, thank you, Steve, and thank you everyone for coming to today's program. So again, like Steve said, we'll talk about the start of the new term later on in the CLE here, but we'll start out by talking about what happened last year. So here's a picture of the court. Not sure when they took this picture, given that the court was at the forefront in terms of COVID lockdowns and hearing arguments remotely, but they have now gathered for their formal picture here. And of course, the big news of the term last year was Justice Barrett coming onto the court. Her confirmation a few weeks into the start of the October term meant that there were just a handful of cases for which she did not sit and hear arguments. And, so while we don't have a full term to see how she voted, we have close to it. And it is very much a new court, following Justice Ginsburg's death and now with Justice Barrett on the court. So how did this all play out? Last term, there were only 54 cases that were decided. On average, since 2008 until last term, 72 cases was the average. And even that is very much on a downward trajectory. If you were to go back as recently as the 1980s, the court was deciding over 160 cases per term. So what's the reason for this downward trend? Well, Chief Justice Roberts has said, he just doesn't think that there are as many cases that the Supreme Court needs to decide. That, the Supreme Court is really there when there are circuit splits that aren't being resolved, when there's conflict with Supreme Court precedent, and that there are less of those kind of cases for which the Supreme Court needs to weigh in. Now, I think it's fair to criticize whether that is in fact true. And like we're going to be talking about a little bit later on, the increased focus on the court's shadow docket indicates that there are important decisions that do require the Supreme Court's vetting, but that they're not always being decided as a full decided case. So we'll talk about more on that later on. Of course, the COVID-19 pandemic also just had an impact on these numbers. So 2019 term saw a dramatic decrease. That inched up a little bit higher this last term, but still nowhere close to where it had been previously. So that's the cases decided. But well, what about the outcome? It's still the rule that while it's very hard to get to the Supreme Court and have your case taken if you're a petitioner, if review is granted, you're likely to win. The court reversed in 80% of the cases that it heard last year, affirming in only 20%. Now, which courts did the best? No federal court of appeals fared particularly well. The 11th Circuit had a 40% affirmance rate, with 2 out of its 5 cases being affirmed, and that's about as good as it gets. Actually, the state court decisions that were before the Supreme Court did better than the federal courts. 3 out of the 4 state court cases that went to the Supreme Court were affirmed last term. There were a number of circuits that had all of their cases reversed: the 1st Circuit, 4th Circuit, 6th Circuit, 7th Circuit, 10th Circuit, DC Circuit, Federal Circuit, all were reversed in 100% of the cases. And the perennial punching bag, the 9th Circuit, wasn't in the 100% club, but it had 14 out of its 15 cases reversed for a 94% reversal rate. So now let's look at how the court was voting in its cases. What were the vote splits? Despite all the talk about how, the newly constituted court with Justice Barrett and this conservative majority was going to potentially run wild and flex its new muscle with that supermajority, the rule, the general trend was that more cases were issued unanimously or with just a sole dissent than any other. So 43% of the cases were unanimous. Compare that to the previous 2019 term, that was a higher percentage of unanimous opinions. The previous term, it had been 36%. And the 43% is pretty consistent with the past decade, which had on average been a 46% unanimous rate. Where it gets interesting and also unsurprising is what's happened with 5-4 and 6-3 decisions. So you can see that 6-3 decisions took up almost a quarter of the court's decisions at 24%. 5-4 decisions were only 12%. That's essentially a flip from where those numbers were last year when Justice Ginsburg was still on the bench. In the previous term, there had been 23% of the court's decisions were 5-4 splits and 11% 6-3 votes. So you have seen that being a material change that can be attributed to the change in the court's composition. So talking a little bit more about the impact of Justice Barrett. In terms of particularly ideologically polarized cases, it doesn't change who's in the majority. It went from maybe a 5-4 majority to now a 6-3 majority. But it did matter in a few key cases, and some of these we'll touch on a little bit later. There were a number of COVID-related restrictions that came before the Supreme Court. Most of those were upheld. The key exception was with respect to religious exemptions from social distancing for religious worship services or things of that nature. Chief Justice Roberts had joined the more liberal members of the court in upholding those. And when Justice Barrett came on the bench, replacing Justice Ginsburg, that was the key vote that switched things over. There was a decision about the constitutionality of appointed administrative patent judges, which was a 5-4 decision with Justice Barrett making a difference. Also, a standing related decision for class action lawsuits where her vote mattered. We'll talk about some of those more later on, but her vote mattered in some. And we'll also see later on as we go through that with Justice Barrett being on the bench, the 6 conservative members aren't just voting as this monolith. You're seeing fractures in the conservative coalition, with some justices wanting to still take a more incremental approach in terms of decision making, potentially have broader consensus among the court, others wanting to seize the moment and really move the ball forward in terms of conservative judicial ideology. And we'll see some of that fracturing and discuss it more as we move past the statistics into the cases that were decided this past term. So who's the new justice who's most often in the majority? It's Justice Kavanaugh, who's now claimed that mantle. Across all cases, he was in the majority 97% of the time. Chief Justice Roberts and Justice Barrett were in the majority 91% of the time. Gorsuch 90%, Alito 83%, Thomas 81%, and then the 3 liberals at the bottom, Justice Breyer at 76%, Justice Kagan at 75%, and Justice Sotomayor at 69%. This is a flip from where it was last term. So last term, you would have had Justices Thomas and Alito in the bottom half of that metric. And now they've moved higher up, and it's the three Democratic appointees, Justice Kagan, Breyer, and Ginsburg, who have moved to the bottom. So there is clearly a split by ideology that has happened. It's also, seeing Justice Kavanaugh there reflects that this is no longer Chief Justice Roberts' court in the same way. Particularly in that period of time when, Justice Kennedy had retired, who had long been viewed as the swing vote. It then became Chief Justice Roberts' court, and he doesn't have the same pull that he had, or the same power of being in the ideological center that he had before. When you take out the unanimous cases and look at the divided cases, so these are cases that are the 5-4 splits and the 6-3 cases, and you look at who is most likely to be in the majority. Again, Justice Kavanaugh was in the majority 95% of the time. Roberts and Barrett next. Justice Sotomayor was most likely to be in the majority only 45% of the time, really being at the bottom there. So she has kind of staked herself out as a dissenting justice with the current court's composition. And with Justice Kavanaugh being in the majority 95% of the time, the only other justice in the past decade to have done that, been in the majority 95% or higher in divided cases, was Chief Justice Roberts in 2012. So that's an indication of how often Justice Kavanaugh is in the majority and how seldom that degree of being in the majority occurs. So who are the justices who are agreeing with each other the most? It's the Chief Justice and Justice Kavanaugh. They agree with each other 94% of the time. The next pair that's most likely to agree on case outcome is Justice Breyer and Justice Kagan. 93% of the time they agreed. Breyer and Sotomayor also agreed together 93% of the time. Justice Barrett and Justice Gorsuch agreed 91% of the time. And Justice Barrett and Justice Kavanaugh also agreed 91% of the time. This is the second year in a row that Chief Justice Roberts and Justice Kavanaugh take the title for being most likely to agree. And the lowest agreement was Justice Sotomayor and any of the conservatives. Again, she has been kind of the biggest dissenter over the past term. And her public comments this past week indicate that there's more to be expected from her on that front going forward rather than less. In terms of who was writing the opinions in the closely divided cases, the 6-3 cases and the 5-4 cases, it was Chief Justice Roberts. He wrote the majority opinion in those kind of cases 5 times, compared to Justice Gorsuch and Kavanaugh, who wrote 3 such opinions. Kagan and Sotomayor wrote 2, as well as Alito. Justice Barrett wrote 1. And Justice Thomas and Justice Breyer did not write any majority opinions in these kind of closely divided cases. This isn't too surprising to see Chief Justice Roberts at the top of the list. One of the things that he gets to do as the chief is select who writes the opinion. And so in these decisions where every vote counts, it's not surprising that he would hold the pen to try to continue to craft that majority. In terms of who is writing the most unanimous opinions, it was actually Justice Thomas this last term. He wrote 5 such opinions. And that's a little bit surprising. Last term, he only wrote 1. Now he wrote 5. When I think of myself back in law school, Justice Thomas was kind of celebrated as this dissenting voice. And those were the opinions that stood out. And more he's writing the majority opinions. In terms of who is now the dissenting judge, well, as I alluded to, it's Justice Sotomayor. She wrote 9 dissents last term, which is more than any other justice. Justice Breyer came in second with 7. Justice Thomas and Justice Alito each wrote 5. Justice Kagan, Justice Gorsuch, Justice Barrett each wrote 3. And Chief Justice Roberts and Justice Kavanaugh each wrote 2. So Justice Sotomayor dissented in more than half the cases this term. So even when she wasn't writing an opinion, she was dissenting in more than half the time. And Linda Greenhouse, a Supreme Court journalist, noted that Justice Sotomayor has adopted the role of writing alone to criticize the court when she believes the majority overlooks or misrepresents the factual history and context behind the textualist opinions that are often getting issued by the court. So as we move past the statistics, what are some of the key takeaways? Some of the key takeaways. Well, again, Justice Kavanaugh has replaced Chief Justice Roberts as the median justice. And there really is no true swing vote anymore. Chief Justice Roberts being in the middle can't change the outcome anymore, even when he joins with the more liberal wing of the court. So there is a clear conservative majority, but as we'll talk about moving into the cases, how that clear conservative majority is choosing to exercise its majority influence was a little bit stilted this past term, and the open question going into the term to follow is what will it look like on a going forward basis. And of course, this is only one term, so it's a limited sample size, And it was a term that did not issue as many opinions as other terms. So it's particularly limited in that respect. Steve?
Let's turn now to the 2020 merits docket and talk about some of the more important cases. You know, in many ways, this term was important for what wasn't on the docket. I think if we think back about a year, there were many concerns about a repeat of Bush v. Gore or some sort of activity by the court with respect to the presidential election. It didn't happen. There were no cases involving hot button issues like abortion or Second Amendment rights or affirmative action, many of which, maybe all of which, are going to be on the docket for the 2021 term. So it doesn't rank as one of the more impactful terms in recent history. And many commentators refer to this 2020 term as more of a transitional or kind of table setting term. But there were some very interesting decisions, and we're going to go through those now. The first case I want to talk about is California versus Texas. So this was yet another attack on the Affordable Care Act. There were two that preceded this. You may remember King versus Burwell, and I think it was the BFIP case. And in the King versus Burwell case, you may remember that the ACA was saved essentially by the court's majority opinion that the individual mandate penalty was a tax, and that made it constitutional and avoided the claims of unconstitutionality based on a variety of provisions. So the Republican-controlled Congress in 2017 said, well, we can fix that. And they left the Affordable Care Act intact, except they eliminated the penalty for the individual mandate. So now the individual mandate remained, but there was no teeth in it. There was no penalty and therefore no tax. And the theory was openly by the Republican Congress that given given the court's opinion that it was the penalty / tax that saved the act, now it would be unsavable. And so the case proceeded up on that basis. And in a 7-2 opinion written by Justice Breyer, the court left the Affordable Care Act in place on standing grounds. And in a sense, the court was saying that the Republican Congress who had passed the law was a bit hoist on its own petard. In order to have standing, one must show that there is an injury that is fairly traceable to the conduct that is alleged to be unconstitutional. Well, the conduct that was alleged to be unconstitutional was a variety of provisions, but none of them had anything to do with the individual mandate because now there was no penalty. And so no one suffered harm as a result of the other provisions of the act, which were alleged to be unconstitutional, and therefore there was no standing. The states argued that they actually did have standing as a result of higher administrative costs of certain of the programs that they now had to administer, but that was rejected by the court in a 7-2 opinion. Even Justice Thomas, who'd been very critical of the Affordable Care Act and prior in the two other cases in which he had dissented, agreed that this was the right outcome. Only Justice Alito was dissenting in this matter. Tim?
Thanks, Steve. The next case we're going to talk about is Fulton v. City of Philadelphia. And this is a case that really hits at the intersection of the principles of the Free Exercise Clause and non-discrimination. So this tension between liberty and equality. So this is a case dealing with Catholic social services, placement of foster care children in the city of Philadelphia, and its policy, which it had been doing for 2 centuries, but its policy that it would not place or refer children to same-sex couples, or for that matter, unmarried persons, based on its religious view of marriage. And the city of Philadelphia, pointing to its anti-discrimination principles, said it would refuse to continue to allow Catholic social services to place foster children unless it agreed to do so to same-sex couples. And so this case really, again, kind of hits at this tension between the free exercise clause and non-discrimination. And this has been bubbling up, based on recent Supreme Court cases. You look back at the 2015 decision in Obergefell, which recognized the same-sex couples had a constitutional right to marriage. In the 2019 term, although not a constitutional case, the Supreme Court recognized that Title VII prohibited discrimination against LGBT individuals in the Bostock decision. But at the same time, in Obergefell itself, the majority opinion made clear that its decision was not intended to tramp down on deeply held religious beliefs regarding marriage. And they confirmed that in the Masterpiece Cake Shop decision a few years ago. So the situation in this case is one that Chief Justice Roberts actually expressly previewed in the Obergefell case, which is, what does the law and Constitution require when a religious adoption agency or here foster care agency declines to place children with same-sex married couples? And Chief Justice Roberts predicted it would get to before the court, and here it did. And here Chief Justice Roberts wrote the majority opinion. So some background that's kind of interesting about this case is the certiorari petition put squarely in the crosshairs the governing Supreme Court precedent, which is the decision Employment Division v. Smith. Now, what that decision says is that is effectively that when a governmental body enacts a neutral and generally applicable law, the fact that it happens to impede the free exercise of religion, so long it was neutral and generally applicable, is only subject to rational basis review, so not strict scrutiny. And what that means is most of those kind of laws are going to survive and pass muster. That decision has now been one that many conservatives have been looking to get overturned. The irony is that Justice Scalia was the one who wrote that opinion. And the interesting wrinkle here is Justice Barrett was a Justice Scalia clerk. So there was a question of, well, how is she going to view this case? What's her vote going to be? This is a decision where Chief Justice Roberts, writing the opinion, was able to fashion what he wishes he could do more often, but it has become increasingly more difficult. And that is he managed to craft a unanimous result. By a 9-0 vote, the court agreed that the city of Philadelphia had overstepped what is permissibly allowed to do here. The key thing about the holding is it did not revisit the Smith decision or the Smith framework. Instead, what the court held is that under the Smith framework that already exists, this decision and the policy went over the line. And the reason for the court's analysis was this. While there is this anti-discrimination provision, it did give the commissioner discretion to grant exemptions basically at his pleasure. And what the court said is that you don't then have a generally applicable policy here if the commissioner can exercise his or her discretion at will. And because this isn't a generally applicable policy, then it's subject to strict scrutiny. And the city of Philadelphia hasn't been able to justify its prohibition on Catholic social services operating in the way it has under a strict scrutiny framework. So that was the majority holding. There were a number of concurrences. Justice Alito, joined by Justice Thomas and Justice Gorsuch, issued a 77-page opinion. And this is the three justice alignment that you see in a number of opinions saying, now is our moment, we could be doing more. And so what Justice Alito says is, in this lengthy opinion, is we should overrule Smith and replace it with another categorical rule that any law that burdens religious exercise must be subject to strict scrutiny. So that's the framework that Justice Alito, joined by Justice Thomas and Gorsuch, advocated for, but that didn't prevail here in favor of the more narrow but unanimous opinion. Justice Gorsuch, again, writing separately, but joined by the same two, Justice Alito and Thomas, criticized the majority for really kind of circumvention and what it kind of criticizes gamesmanship. The Supreme Court granted review on the question of whether to revisit Smith, and Gorsuch criticized the majority for dodging that issue. Since Smith was squarely on the table for the court to consider and reconsider, Justice Gorsuch felt like the court should have done so, and it didn't here. Interesting in terms of seeing where Justice Barrett is at least coming out now in the short term. She wrote a concurrence joined by Justice Kavanaugh as well as by Justice Breyer, who joined most of it, just not the first paragraph. And what she said is Justice Barrett expressed her view that the petitioner had made some serious arguments that Smith ought to be overruled and credited that. Now, Justice Breyer didn't join on to that, but it's notable that Justice Barrett echoed criticism of the Smith decision. But she then went on to say, we don't need to revisit it here. And she did express concerns in swapping one categorical rule for another, particularly where you do have these different competing constitutional provisions that are coming at a head and coming at each other. So I think it's just a very interesting case, a significant one. The unanimity is significant, but you also see the fracturing among the conservative majority. Steve?
The next case is Bernovich versus Democratic National Committee. And this was one of the first cases under Section 2 of the Voting Rights Act. You may remember the case, I think it was from 2 years ago, Shelby County versus Holder, in which there was a decision that dealt with pre-clearance of certain state laws to determine compliance with the Voting Rights Act. And that was the court cut back on that. It was very limited, but the court noted in that opinion that Section 2 remained intact essentially to provide protection to voting rights. Well, this case dealt with Section 2 of the Voting Rights Act, and Section 2 prohibits a state from abridging the right to vote on account of race or color. And in this case, it dealt with a policy and a law in Arizona regarding time, place, and manner of voting. Arizona permits each county to choose a vote center on a precinct-based system for in-person voting. And in counties using the vote center system, registered voters may vote at any polling location in the county. But in counties using the precinct-based system, they have to vote in the precinct. And if you vote in Arizona, if you vote in the wrong precinct, your vote will be tallied as a provisional vote. But if it's later determined that you did vote in the wrong precinct, instead of transferring it to the right precinct, the Arizona policy was simply to throw the vote out. In addition, Arizona had allowed for another form of voting. So, and that is a voting in which votes in which the voter can drop off early votes at a voting center. And Arizona had permitted the collection of votes to be dropped off at a voting center in the past. And as the court noted, there had, in the long history of this law allowing it, there had never been any indication or allegation of fraud. Nevertheless, the Arizona legislature passed a law prohibiting vote collection, essentially, and using in early voting in connection with these vote centers. So there was a challenge that this by the Democratic Committee in Arizona that these laws were racially discriminatory in intent and effect, and therefore violated Section 2 of the Voting Rights Act. In a 6-3 opinion, so this is one of the 6-3 opinions that Tim mentioned, authored by Justice Alito with a concurring opinion by Justice Gorsuch, the court held that the Arizona policy regarding the throwing out of votes that are at the wrong precinct and the law prohibiting collection did not violate Section 2 of the Voting Rights Act. The court held that neither imposed a burden on voters that exceed the usual burdens of voting, and any racial disparity in the burdens is, quote, small in absolute terms. And the court held that the state had legitimate and important interest in ensuring even distribution of voters among polling places and preserving the integrity of election procedures. I think the significance of this case is the court signaling again the reluctance of the court to use the Voting Rights Act to invalidate state laws that govern voting. And as we see a number of states passing voter restriction laws, there are likely to be a lot of challenges to those laws coming up. And I expect that we'll see some of those in this term. But the court, it seems to me, in a 6-3 decision, is signaling that's going to be an uphill battle for plaintiffs to prove that these voter restrictions were intended to be racially discriminatory or have a racially racially discriminatory impact such that they violate Section 2 of the Voting Rights Act. Yeah.
Thanks, Steve. So the next case is one that grabbed headlines. It's the NCAA v. Alston. And this is the case about whether student athletes should be limited just to their scholarships or whether they should be able to be compensated, receive additional funds, things like that from the universities. And, people have strong views on this issue. Is there something to amateurism in college sports that is important to preserve? Or to what extent, is the NCAA just a giant monopoly that's, suppressing the student athletes and getting rich off their uncompensated play? So strong views on the issue. Politically, the question here for the court really came down to what about antitrust law as it exists? Do general antitrust principles apply to this case and this question the same as they would in other cases? Or do we look at the NCAA differently because it's the NCAA, because it's sports, because of amateurism? So that's the question that came to the court. The district court in this case out in California and affirmed by the Ninth Circuit said, I'm going to apply general antitrust principles. The predominant one being applying a rule of reason analysis. And what the rule of reason analysis generally is it's a request for a court to conduct a fact-specific assessment of market power and market structure to assess a challenged restraint's actual effect on competition. And then the goal based on this kind of fact-specific assessment is to distinguish between restraints with anti-competitive effect that are harmful to the consumer and restraints that are stimulating competition that are instead in the consumer's best interest. And so the district court engaged in this lengthy analysis. There was a lengthy trial, 50-page opinion, and the district court recognized that there were restraints on competition here, noted that the NCAA had a countervailing interest that it identified in preserving amateurism, and based on its weighing, issued again a lengthy opinion in which it effectively split the baby. It said, it's okay, and I understand the NCAA not allowing like professional athlete level payments being able to be made to student athletes. But on the other hand, there's no reason to have the caps that were currently in place on certain benefits that were still tied to education in some way. So that's how the district court split it. The Ninth Circuit affirms. And then the petition to the Supreme Court came solely from the NCAA. So the players were no longer asking for more. The NCAA was just asking to reverse kind of the narrow the narrow ban that the district court had said the NCAA couldn't apply anymore. And the Court of Appeals opinion, written by Justice Gorsuch, took a lot of time to make sure to identify the narrow scope of the opinion that it was issuing, all the different concessions that were made by the different sides that really made the issue relatively narrow for the court to face. And what the court ultimately concluded is that standard antitrust principles should apply here, that there shouldn't be any exception for the NCAA in this circumstance, and that when you are dealing with a very fact-specific antitrust law analysis, it wasn't possible to say that the district court got it wrong here, and it therefore affirmed. So the main arguments that the NCAA raised were, again, that this rule of reason analysis shouldn't have been triggered in the first place. The court, though, looked at general background antitrust principles and said, well, there's no reason to not apply the rule of reason in these circumstances, even if, for example, the NCAA is effectively a joint venture. The big case that really loomed large is a decision from the Supreme Court back in 1984, NCAA v. Board of Regents of the University of Oklahoma. In that case, the Supreme Court had struck down the NCAA's television plan as violating antitrust law, but had language in that opinion indicating that it was applying different rules from an antitrust perspective there than should normally be the case. And so the NCAA for years has kind of relied upon that past 1984 decision to say, we are different. And what the court held was, no, you're not. It said that effectively stray language in that 1984 decision shouldn't, become the tail wagging the dog here, that there's no reason to apply different principles. And particularly when antitrust law is really based on a fact-specific analysis based on current market realities, those market realities have changed in the decades since that 1984 decision had issued in such a way that that would be an independent reason to just apply standard antitrust principles here as well. The last argument that was thrown up was, well, baseball is different. In 1922, the U.S. Supreme Court had issued a decision saying that baseball is exempt from antitrust principles. And the Supreme Court said, yes, we did say that. We've also gone out of our way to say that that decision's an aberration and that we're not applying it to any other sports. And so it said we're not going to extend that further. One thing notable about this decision, again, for it being a high-profile case, it was unanimous. Unanimous decision by Justice Gorsuch, a sole concurrence by Justice Kavanaugh, who would have gone even further. The reality is, even though this decision was narrow, the effect has been much broader. The NCAA afterwards said, we're just getting out of this altogether. And so it eliminated all of its prohibitions. And so now you are seeing compensation for athletes, things of that nature, even though the narrow scope of the opinion that was actually at issue wouldn't have allowed things to go that far. Steve?
The next case is Mahanoy Area School District versus BL. And this was my favorite case of the term, and that probably says a lot about the kind of cases that came down this term. You probably saw the news about this. A high school girl, I think she was 14 years old, tried out for the varsity cheer team, and she did not make the varsity team. She did make the junior varsity team, but she wasn't very happy about that. So she made a post on Snapchat of herself, and underneath the picture of herself, she said, and there were no asterisks in the snap, it said F school, F softball, F cheer, and just to be sure that you were aware that she was experiencing some disappointment, F everything. So that violated some rules that she had agreed would apply with respect to her demeanor and speech. And she was suspended from the junior varsity team for a year. She sued the school under 42 USC section 1983, alleging that her suspension from the team violated the First Amendment, that the school and the team rules regarding speech were overbroad and viewpoint discriminatory, and that they were unconstitutionally vague. And so this wound its way up through the courts until it was before the U.S. Supreme Court. And this is probably the most important school speech and freedom of speech case since Tinker versus Des Moines School District in 1969, I think it was. In Tinker, the court dealt with speech that was essentially on campus. This was speech that was off campus. So when she made the Snapchat, it was over a weekend. She was not on school campus. She was on her own time in her own home when she posted it. Now, the court has recognized that under various circumstances, a student's indecent, lewd, or vulgar speech on school grounds, speech promoting illicit drug use during a class trip, and speech that the others may reasonably perceive as bearing the imprimatur of the school, such as appearing in a school sponsored newspaper, can all be subject to regulation by the school, at least in certain circumstances. The courts also held that schools may also regulate speech that materially disrupts classwork or involves substantial disorder or invasion of the rights of others. In an 8-1 decision, in this case, authored by Justice Breyer, the court found that the school's rules here did violate the student's First Amendment rights. They really set some guidelines for off-campus speech in this case. They noted that off-campus speech normally falls within the zone of parental responsibility rather than school responsibility. That off-campus speech regulations coupled with on-campus speech regulations would mean a student cannot engage in the regulated type of speech at all. And they also noted that the school itself does have an interest in protecting a student's unpopular off-campus expression because the free marketplace of ideas is a cornerstone of our representative democracy. In this case, the court found that it was the parents and not the school that had responsibility for the student and for her social media post, and that there was no evidence of substantial disruption to the school or school activities, and it didn't threaten to harm the rights of others. So the court found that her First Amendment rights had in fact been violated by the state's rules. I'm guessing that she is still on the junior varsity team. There's no indication that they bumped her up to varsity because of this, but at least she has her 1983 action. There was one dissent, and that was Justice Thomas, who indicated that schools had historically the authority to regulate speech, even if it occurs off campus, and found that in this case, he believed that the school did have the right to essentially to censure the student for making this kind of post that was directed to a school activity. Tim.
Thanks, Steve. So I'm going to talk briefly about a trifecta of cases involving federal agencies. The Supreme Court in recent years has started to scrutinize and push back on the structure of federal agencies and police the separation of powers with respect to the Appointments Clause, Inferior Officer Clause. And so as a litigant, if you find yourself being regulated by a federal agency, there may be grounds to challenge the agency's action by arguing that the decision maker is not properly constitutionally vested to make those decisions. If you find yourself before an administrative law judge regulated by any of the various different administrative agencies, there may be arguments out there that that administrative law judge lacks the authority to issue the decisions that he or she is issuing. And so decisions came out a few terms ago challenging these. There was a decision, Celia Law, involving the Consumer Financial Protection Bureau that I'll talk about in a second. There was a decision involving SEC judges that came out. And what you saw this past term is kind of the trickle down. So now that the court has started to identify that there are sometimes Appointments Clause issues, things of that nature with administrative law judges or directors, the questions are, well, what are the remedies? To what extent does this blow everything up that the agency has potentially done or administrative law judges have issued? To what extent can others piggyback on those cases and be bringing those challenges in court to try to get their challenges reversed? So the Yellen v. Collins case dealt with the Federal Housing Finance Agency, and the holding there, and that agency is one that acts as a conservative for Fannie Mae and Freddie Mac. The challenge there was that the Recovery Act structure restricts the president's power to remove the FHFA director and violates the separation of powers. So under the Appointments Clause, the president has the power to appoint, and then the Senate has the power to confirm. Anyone who is appointed at that level, it's been held, has to be removable by the president at will. If there are any sort of restrictions on the president's ability to remove that level of an officer, that is held to violate the Appointments Clause. And here the issue is that the FHFA was led by a single director appointed by the president with advice and consent of the Senate, but serves a 5-year term and may be removed by the president for cause. And the court in its holding, this was Justice Alito joined by Chief Justice Roberts, Thomas, Kavanaugh, and Barrett, held that looking at the Celia Law case that dealt with basically the same finding with respect to the Consumer Financial Protection Bureau, this structure does not work. Instead, the director needs to be removable for cause. The question here was, well, what's the remedy in this case? And ultimately, the court punted that back down. So we'll need to wait to hear the final answer. The actual relevant decision that was before the court there was a decision that was issued by an acting director. And so, and that acting director was removable at will. At the same time, the court recognized that there could potentially be some retrospective relief and thus sent it back down. The middle case, the Arthrex case, this was a patent-related case. There's a process called inter partes review where you can challenge a previously issued patent. That decision, that review process is heard by a panel of 3 administrative patent judges. Those patent judges are appointed and generally subject to review by the director. But when they've issued their decision, the director is not allowed to review that decision at all. Instead, it goes straight over to the Federal Circuit for review. And what the court held in this case is that that is unconstitutional. Unless the lower level director has the ability to review what those administrative law judges are issuing, it's unconstitutional. There needs to be that level of review. So Chief Justice Roberts, writing from the majority of the court, held that that was unconstitutional. The remedy that the court came up with was just to eliminate the provision that took away the director's review. So now decisions are reviewable by the director. that was considered to be a softer and easier fix, and actually was joined by the more liberal justices who would have upheld the whole scheme, but when it came to the remedy point said, well, we agree with this kind of narrow thing rather than kind of blowing up the whole scheme altogether, which is what the alternative would have been. The other note here is the court did not take the more extreme measure that some thought it might, which would have been overturning rulings by prior panels of administrative patent judges. Instead, what's been established is a process providing litigants with an opportunity to seek discretionary review by the USPTO Director of Patent Judges' decisions. So I think the takeaway here is that the court is continuing to recognize that where there are constitutional infirmities in terms of the structure is going to speak out and hold those to be in violation. But it's trying to avoid opening the floodgates and creating a kind of opening Pandora's box in terms of unforeseen results, in terms of how easy it is then to challenge going forward. The Davis v. Saul case is similarly consistent with that. Here, people who are challenging Social Security administrative decisions were already in federal court outside of the administrative court process when the court's decision saying that the SEC structure violated separation of powers was unconstitutional. And what the court held here unanimously is you didn't need to raise it at the administrative law stage in order to preserve it now, as long as you were still in federal court when this decision came down. So again, for those who find themselves on the defense side or in this kind of litigation, there may be room to make these kind of arguments if you haven't already. And there may be new agencies that have some structural infirmities as well, as the court continues to kind of beat back on the way that these agencies are structured. Steve?
I'm just going to take a minute to talk about Goldman Sachs Group versus Arkansas Teacher Retirement System. So this was a case that involved factors dealing with the courts, refinement of the courts holding in the basic case regarding reliance and security fraud cases. So you may know that in securities fraud cases, under the basic decision, a plaintiff can show a rebuttable presumption of reliance based on the movement of market prices because of the assumption of an efficient market. The court has had a number of decisions sort of around that and how that should be applied. Here, the court the majority of the court found in a 9-0 holding that court should assess the generic nature of statements when determining price impact under the basic theory. And it also held, which I think would be widely considered to be kind of a defendant-oriented provision, but in a 6-3 part of the decision, the court held that the defendant in such a case has not only the burden of production, but the burden of persuasion in rebutting the presumption. So I think would widely be considered a more plaintiff-oriented approach. So kind of a split decision in that case. So Tim's going to talk a little bit more now about Justice Barrett and in some cases and the sort of textualist approach that she has brought to the court.
Thanks, Steve. So Justice Barrett does subscribe to textualism, but what these cases highlight, and particularly the second two, VanBuren and Holly Frontier, what they highlight is that even among those justices who subscribe to a textualist approach, that the textualist approach can lead them in different directions and to different results. So it doesn't mean that everything is resulting in a 9-0 opinion or a 6-3 decision along clean kind of Republican versus Democrat appointee lines. So the VanBuren case dealt with the interpretation of the phrase exceeds authorized access. So in the Computer Fraud and Abuse Act of 1986, someone can be criminally prosecuted if they exceed authorized access of a computer. And so the question before the court was, what does it mean to exceed authorized access? Justice Barrett wrote the majority opinion, joined by the more liberal members of the court, along with Chief Justice Roberts and Justice Alito. And her textual approach was to say exceeds authorized access means to access a computer with authorization and to use such access to obtain information in the computer that the accessor is not entitled to so obtain. So it would mean going through and saying, I have permission to access these files, but not these files, to access these folders, but not these folders. the dissent's approach, and the dissent was written by Justice Thomas, joined by, I'm sorry, I was wrong. The dissent was written by Justice Thomas, joined by Chief Justice Robertson Alito. So it was Justice Gorsuch and Kavanaugh who joined Justice Barrett. Justice Thomas also took a textualist approach, but came to a different conclusion as to how an ordinary reader would construe the phrase exceed authorized access. In his view, the circumstances matter. So, so he gave an example, for example, of, you know, being a valet gives you a right to drive your car, but doesn't mean the valet can go for a joyride. And so similarly, it's not just a question of whether you have access to particular folders, to particular files. Your intention or the reason for accessing those particular files would matter. It also would have expanded the scope of the statute and the criminal prohibition there. So that's one example of a factor in terms of the textualist approach. The Holly Frontier case is another example. This is a case dealing with a refinery permit, and there are certain exemptions that that a refinery could obtain under federal law, and could then also obtain an extension of that exemption if needed. Well, what happened factually in this case is the exemption had lapsed in time, and then an extension was sought. So the textualist question is, what is an extension? And can you seek an extension of time even after a lapse? Well, the majority opinion, written by Justice Gorsuch, said yes. That is an entirely natural and consistent with ordinary usage, that one can seek an extension of time even after a lapse. Justice Barrett dissented and said no, and was joined here by Justice Sotomayor and Justice Kagan, so an interesting alignment. And Justice Barrett again took a textualist approach and said the text and structure make clear that the EPA cannot, quote, extend an exemption that a refinery no longer has. Justice Barrett acknowledged that the majority adopts a possible meaning of the term, but says we don't take the outer limits of a term's meaning at the expense of its ordinary and common meaning. Instead, we look to the most natural reading. And so again, you know, this is just, these cases aren't particularly important or significant, but I think it is significant in showing where there can sometimes be friction even among justices who in theory subscribe to the same approach. And, you know, looking at cases for the future, for next term and in the terms ahead, it could again just show how there sometimes there will not always be just a straight 6-3 vote. There are interesting voting alignments that can arise. Steve?
Tim, why don't we skip over to the shadow docket section, just in the interest of time. So we're going to talk a little bit now, as I mentioned at the outset, about the shadow docket. So first off, what is it? This term itself was coined a few years ago by a professor at the University of California. And it's a way to refer to essentially what used to be called the order calendar or the order docket. The Supreme Court makes thousands of orders and decisions that sort of bypass the normal procedure for briefing, for cert, and for merits. And most of these are very mundane. They have everything to do from extensions of time to admissions to the bar, you name it. They're very, very perfunctory and administrative. But some have, and increasingly more often, some deal with significant and substantive matters, and these are generally in the form of emergency applications and the orders on those applications. So you probably know merit docket cases, they follow a consistent, a well-known process. There's extensive briefing, there's a chance for amicus briefing, both on the petition for cert and on the merits. There is oral argument. It's all very public. Decisions are signed. We all know who makes the decision. Now, the shadow docket decisions are much more ad hoc, and they usually only consist of a single round of briefing. There's, if that, there's rarely any oral argument. They're often on a very compressed schedule, like emergency requests for a stay. They're often resolved in brief orders with little or no reasoning. And there's no guarantee you know which justices vote which way, because it's not always apparent from the decision itself. So why is the shadow docket getting so much attention? Well, obviously, it's been in the news very recently because of the Texas abortion law, and I'll come to that in a second. But there are actually a lot of reasons why the shadow docket is coming under increasing scrutiny. We don't have great historical data for this because it's only been tracked in recent years. But there are some data points that I think are illustrative and indicate why the shadow docket is coming under scrutiny. First, the court has been granting emergency relief. So these are orders on emergency applications much more often. We got a chart. Thanks, Tim. And you can see how the trend has been over the last several years. We've gone from a situation where you might have just one application for emergency really, or one grant of a stay per year, to now where there's a total of 20 grants for emergency relief. And these used to come up in sort of predictable cases. Some had to do with elections, like in the Bush v. Gore context. More often they had come up historically in cases involving the death penalty and seeking stays for prisoners who were under threat of execution. But they're coming up much more frequently and in much different contexts. Second, the Department of Justice has been increasingly making applications for emergency relief. From 2001 to 2017, during the Bush and Obama administrations, so this is 16 years, DOJ made exactly 8 emergency applications. And on the orders for those, only one of the cases involved a dissent. The Trump administration, in comparison, made 41 applications in just 4 years. And the majority of those led to at least one dissenting opinion. They became such a feature of Trump's tenure that the SG's office restructured its staff to deal with the emergency applications. Another reason why the shadow docket is coming under scrutiny is that they are increasingly being used in high-profile and politically charged cases. So no longer confined to death penalty cases, no longer confined to sort of emergency situations involving an election. Now we're seeing emergency petitions that deal with a wide variety of very controversial subjects, such as the recent Texas abortion law. And it's also the case that what we're seeing is 5-4 decisions on the shadow docket on these emergency applications. And in fact, in 2020, there were almost as many 5-4 decisions in shadow docket cases as there were on the merits docket. So there were 11 5-4 decisions on the shadow docket, 12 on the merits docket. Lastly, justices are more frequently using shadow docket decisions to change the status quo, not simply to maintain the status quo, which had really been the norm prior to the last few years. The justices are lifting stays of lower court rulings or enjoining practices for the first time. The court, if we look at this, actually, you'll see that the court granted 7 emergency petitions into the 2020 term. Before that term, the Roberts Court had granted only 4 emergency injunctions during the entire Roberts tenure. COVID has increased this because there's been a number of COVID-related emergency applications. So it could be that is skewing things up, but we'll see that it's not just COVID that's driving the numbers. So let's take a look at some of these decisions. The one that's probably most famous or infamous, depending on your view, is the recent Texas abortion decision. And that is a law, it's on the books now, that essentially outlawed abortion after 6 weeks and empowered essentially bounty hunters to enforce the law. The shadow docket decision on this, so involving very limited briefing, no oral argument, was 5-4 to leave the law in place. The decision was a single paragraph. It was an unsigned order, and by implication only, because it's not signed, it was apparently voted for by Alito, Thomas, Gorsuch, Kavanaugh, and Barrett, and we only know that because of the dissent. And dissents were filed by Roberts, Breyer, and Kagan and Sotomayor in a variety of combinations. The stated reason for the Supreme Court passing on this law that clearly violates the viability standard of Roe versus Wade was that there were procedural issues that the plaintiffs had not accounted for, namely this sort of bounty hunter provision. That certainly did not deal with and overlooked the fact of the unconstitutionality and the immediate effect it had and predictable effect it had on abortion providers in Texas. But essentially, there you have it. The court said it was taking no position on the constitutionality, said it recognized that there were some serious issues about constitutionality, but refused to take any action. The next slide, please. So with respect to COVID decisions, a number of these are on the shadow docket this year, and there were too many to really talk about. But Justice Barrett clearly had an impact here. The court denied the first two applications for emergency relief from COVID restrictions on religious gatherings before she joined the court. After she joined the court granted a half a dozen cases out of California and New York where the claim was that emergency restrictions imposed by local or state authorities impinged on religious rights. And in these cases, the court overrode public health restrictions put in place by state governments during the pandemic. And there were, as I said, there were 4 of these decisions. There was another decision, Tandon versus Newsom, in addition, that really expanded the concept of free exercise. And some have called it the most important free exercise decision in the last several years. But again, very limited briefing, no oral argument, no formal opinion. There was, next slide, please, Tim. There was one decision relating to the 2020 election where the court came out of Wisconsin. You may remember this. A district judge had extended the date for the counting of absentee votes. That was stayed by the Seventh Circuit. So in other words, the extended deadline was not enforced. And in that case, the Supreme Court declined to take action at all, leaving the Seventh Circuit's stay in place and effectively invalidating the district court's extension of the deadline for counting absentee votes. It's notable that there were some mistakes in that case that led to a corrected opinion, but it's just kind of emblematic, I think, of one of the issues with the shadow docket is things are happening very, very quickly and don't have a chance to be vetted. Next slide, please. So one of the other things that's coming under increasing scrutiny, and I think has led to the justices taking their show on the road essentially to try to make the case that they aren't political, is sort of the political nature of or the political outcomes that have resulted from the shadow docket decisions. So the Trump administration made unprecedented use of the shadow docket and won a solid majority of its requests for emergency relief. It sought emergency relief 41 times, as I said, and it was successful 28 of those times. The Biden administration, not so much. It's only sought emergency applications twice, and in both of those cases, it was turned down by the court. So these are some of the indications of the controversy over the shadow docket and some of the reasons why there's been such scrutiny of it. What's coming up? I think it's likely that we're going to see shadow docket decisions dealing with vaccine mandates and claims that vaccine mandates violate religious rights or something similar. It's certainly possible that there will be other sort of hot button issues that come up quickly. For example, if Democratic legislatures and states decide to impose their own sort of bounty restrictions similar to the Texas law, I think we can expect to see on gun rights, for example, or some similar issue, we can expect to see some shadow docket decisions on that. So a growing and interesting and difficult and controversial aspect of the Supreme Court decision making in the last few years. Yep.
Thanks, Steve. So we'll end by giving a preview of the term that's up ahead. And there are some hot button issues that the court is going to be taking up, starting with abortion. So while the Texas the Texas abortion law has been grabbing the headlines lately. The Supreme Court last term had already agreed to hear a significant abortion decision this upcoming term, and it's Dobbs v. Jackson Women's Health Organization. This concerns Mississippi's ban on abortions after the 15th week of pregnancy, subject only to limited exceptions for health emergencies or fetal abnormalities. What's significant about the court taking review of this case is that it's widely recognized that the law is unconstitutional under the current Supreme Court framework, whether you're looking at Roe v. Wade, Casey v. Planned Parenthood, that the law is a challenge to that because of its restrictions on pre-viability abortions. The Supreme Court didn't have to take this case. The district court had held the law unconstitutional. The Fifth Circuit had done the same thing. The Supreme Court took a lot of time to decide whether to take the case and ultimately granted a review. And what's notable is the question that it granted a review on. The question that it granted a review on is whether all pre-viability prohibitions on elective abortions are unconstitutional. The way that question is framed is one where the court could choose to revisit Roe v. Wade, revisit Planned Parenthood v. Casey. There were other questions presented that would have been more modest in scope, asking how this case fits in within the current framework. The court did not grant review on those issues and instead solely granted issue on the framing of the question that squarely implicated the court's ability to revisit those past precedents. And so that case will be argued December 1st of this year. Steve?
There's a very important Second Amendment case on the court's docket. It's New York State Rifle and Pistol Association versus Bruin. It is probably the most important Second Amendment case to come before the court since the Heller decision in 2010. Heller dealt with a person's right to bear arms in connection with their home. So it was the theory was that a restriction on their right to bear arms in connection with home safety would fall to the Second Amendment. This case deals with Second Amendment rights outside the home, and it's probably going to be give us a good look at how the court is viewing the Second Amendment when it comes to allegations of protecting and personal safety, but outside the home. Tim?
Affirmative action may be on the court's docket as well. So the court hasn't granted review in a case yet, but there's a case challenging Harvard's admission scheme where the court has called for the views of the Solicitor General. And that moves the likelihood of success up to about the 50-50 line. So it at a minimum indicates the court is interested in the issue. What's notable about that petition, one of the questions posed is simply, should this court overrule Rudder v. Bollinger and hold that institutions of higher education cannot use race as a factor in admissions? So the Rudder decision involved the University of Michigan and said that effectively a numerical score could not be given to race in the admissions process, but that it still could be a factor, recognizing that there's a compelling governmental interest in racial diversity. The court, again, is being asked to expressly overrule that decision, which is notable. The other notable thing is that this challenge is to Harvard, a private institution. Most of the other affirmative action cases have been to public universities. The argument is that Title VI of the Civil Rights Act has been held to extend the 14th Amendment's protections when it comes to private universities that are accepting public funds. And so that's the way to challenge Harvard's policy here. The challenge in this case has been brought by Asian American applicants who claim that Harvard is penalizing them because of their race in comparison to other racial groups. So stay tuned to see if that one gets granted or another affirmative action case. Steve?
The court almost every term takes at least one capital punishment case. And it has this term as well, Ramirez versus Collier. There's a Texas law that permits a pastor to accompany a death penalty defendant to the execution chamber, but forbids the pastor from laying hands on the defendant as the defendant's being executed. the defendant in the case is arguing that that violates his free exercise of religion rights, and that's the basis for the lawsuit. Typically, the court has been very deferential to prison officials or state laws that deal with method of execution or procedures relating to execution. It will be interesting to see how the court comes down in this case because of the allegation that it interferes with religious rights. And I think it's if I had to predict, given the trend of the decisions relating the favoring of religious rights over states' non-constitutional issues and non-constitutional rights, we're going to see a decision on the side of religion in that case.
And Steve, I'll put it back to you. The securities litigation case actually settled. So despite being able to get up to the high court, the parties are finalizing the settlement agreement. So the issue in that case is no longer going forward.
So the last case is a First Amendment case, and it involves the city of Boston's refusal to allow a Christian civic organization to raise its flag on City Hall flagpoles that were designated as public forums. And the claim here by the plaintiff is that the court basically that these are free speech restrictions that discriminate based on religious viewpoint and content, and that they also violate the Establishment Clause. So one in a very long series of decisions that relate to how religious displays are dealt with in public forums. Well, we're just about at our time. I think we have 2 or 3 minutes left. Thank you all for joining us. I'm going to look. I think there are a couple of questions here, which we might just take in the 2 minutes that we have left. The first question I was seeing was, why don't we see any lawsuits challenging the way the Senate handled the last 2 appointments? I think the answer to that is pretty clear. This has to do with essentially Senate procedure and political procedures. And the court has been very, very loath to weigh into procedural issues in Congress and how Congress passes laws and how Congress deals with political appointments. The next question I think has to do with the Ford case. And Tim, do you want to talk about that? The minute we have left.
Sure. So the question was, why do you think the court granted cert in Ford Motor Company v. Montana, 8th Circuit, 8th Judicial District Court, and Ford Motor Company v. Vandemer? Those were 2 decisions coming out of state Supreme Courts, Minnesota and Montana. The question was, the opinion did not seem to move the personal jurisdiction needle very much. So those were both personal jurisdiction cases. I think in terms of why the court granted review, you had 2 decisions coming out at the same time on similar facts from 2 state Supreme Courts. The counsel involved in the case already at the state court level, all the way through the Supreme Court, was counsel. I forget the name, but it was counsel who often appears at the Supreme Court, and so it had a certain weight to it in that respect. And I do think that part of the reason that to the extent the opinion did not seem to move the needle very much, part of that may just be because it was a unanimous opinion. I don't know that the decision was a foregone conclusion. The Minnesota Supreme Court held that personal jurisdiction existed, but held so over dissents. So there wasn't a unanimous view going up to the Supreme Court necessarily. And it did clarify some issues of gray in terms of where personal jurisdiction can extend, even if it grounded it in its past precedents. The bottom line is, personal jurisdiction was found to exist in those cases over Ford. And what the court noted in a footnote in that opinion was that what still remains kind of the open question is, to what extent does personal jurisdiction extend when you have, let's say, someone who operates a small business out of their home and is selling things online to consumers across the 50 states. To what extent can personal jurisdiction be extended by another state where a single good is sold? A wood carver making duck decoys was the example the court used, and that'll be kind of the big question that the court has continued to dodge over the years, but at some point we'll have to address.
I think we're right at our 75-minute time limit. I see there's one question left. I'll answer it very succinctly. We'll see. is there a reason can a private bounty approach be used in other matters? I think a lot of that will depend on the Texas abortion case, which will eventually, I suspect, make its way up to the Supreme Court, or could be affected by the Mississippi case. I don't know, but certainly the theory is applicable in other contexts. So thank you all for joining us. I'm sorry we had to do the Zoom approach again this year. I'm hoping next year we will do it in person, but we wish you all well, and thanks again for attending.